Hello, 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 everyone. This is your girl. It's late. I know. I'm sorry I'm coming on so late, but I just wanted to get this to you guys, just in case I don't get a chance to get on here tomorrow. What I'm on here for, this is an update on the Illinois federal case. You guys know Jennifer, she presented the court with two motions: a motion to dismiss the case, certain counts, and also a motion to sever. Well, the judge denied both. He denied both. Um, the motion to dismiss certain counts, the judge was asking, R. Kelly was asking, no, but she was asking for it to be dismissed because of the statute of limitation had run on those counts. So, um, unfortunately, the statute that Jennifer was talking about, that where the statute had run, that particular count was amended. So the judge decided to go with the new version to hold him accountable for the allegations that's been alleged against him. So there we go again. Yeah, yeah. And as to the motion to sever the trial from McDavid, it's not happening. He denied both of the motions. And the reason why he denied the motion with McDavid, he's citing R. Kelly. Basically, he didn't give a legitimate reason. He doesn't see where he may be prejudiced if they were tried together. Yeah, this is ugly. I mean, it's just terrible. And then he waits till today to submit this, to enter his order, because this is an order from Judge Lane Weber. And I don't know if most people know, this judge has he has cases that he done dealt with these people, this Glosman guy, in the past. So he basically, I don't know, I don't know. But this is another sad day to me, because this man, I just find it ironic that the judge waited to enter this order today. I guess they wanted to see how the sentencing went in New York for him to see decide. Because this is some BS. Let me read it. I guess I'll read it. I was not going to, but I will read it. Uh, the statement. On February 13, 2020, the government filed a superseding indictment charging defendant Kelly with 13 counts, defendant McDavid with 4 counts, and defendant Brown with 1 count. Defendant McDavid previously moved to dismiss count 5. This court denied that motion. Defendants filed another motion to dismiss, arguing that all counts except count 5 should be dismissed. Defendants argued that the counts are untimely and barred from the statute of limitations. Number one, counts 1 through 4. Counts 1 through 4 of the indictment charged defendant Kelly with producing 4 videos of a minor engaged in sexually explicit conduct in violation, and there's a statute there. The indictment states that the videos were produced between 98 and 99. At the time of the charged conduct, the statute of limitations expired once the minor reached the age of 25. But it was amended. That's the statute of limitations from 1994 was amended in 2006. Kelly argues that as a result, these counts are time barred. In response, the government argues that the limitations periods was extended when the statute was amended, and the extended date should apply, as that statute was amended in 2003, extending the statute of limitations to life of the minor. There's another statute of 2003, amended in 2006. The statute was amended again in 2006, extending the statute of limitations to the life of the child or 10 years after the offense, whichever is longer. Puts the statute again. If the operative limitations period is the one set out in the 1994 version of the statute, counts 1 through 4 expired in 2009. If the amended statute of limitations applies, the counts are timely brought. The Supreme Court has set out a two-step test to decide whether a federal statute applies to past conduct, and that's the Landgraf test. The first step is to determine whether Congress has expressly prescribed the statute's proper reach. If the statute's proper reach is clear, the inquiry ends there. However, if the statute is silent, the next step is to determine whether applying it retroactively would impair a party's right. Defendants urge the court to look to the legislative history of that statute, 18 U.S.C. Section 3283. That's the statute that they referencing, and ruled that Congress expressly prescribed that the statute does not apply retroactively. Defendants point to the House version of the bill, which contained an express retroactivity provision. Child Abduction Prevention Act, H.R. 1104, 108, Congress Section 202, 2003. The final version of the bill omitted this provision, and Senator Leahy confirmed that the omission was intentional. Senator Leahy, Amber Legislation, Congress Record 149, 2003. Judge Nathan of the Southern District of New York recently dealt with this precise issue in the prosecution of defendant Ghislaine, I don't know if that's the correct pronunciation, Maxwell. United States versus Maxwell. There, Judge Nathan analyzed 18 U.S.C. Section 3283, finding that Congress not only permitted but intended that statute to allow prosecutions for past conduct for which the statute of limitations has not expired. The court agrees with Judge Nathan's analysis, which each amendment to the 18 U.S.C. Section 3283, the statute of limitations increased. In light of the lack of retroactivity provision, but steadily increasing statutes of limitations, the court finds that the statute does not prescribe its proper reach. The court moves to the second step of the Landgraf test. The court finds that applying the current version of that statute would not impair the defendant's rights. In the Seventh Circuit, applying procedural statutes, which effectively enlarge the limitations period, does not violate the ex post facto clause so long as the statute is passed before the given prosecution is barred. And they cite another case. However, in their motion, okay, I'll say the darn cases. U.S. versus Gibson has the case cite there, and then the Strongner versus California. However, in their motion to dismiss, defendants urged this court to read the second step of Landgraf as providing broader protections for criminal defendants than the ex post facto clause. Motion to dismiss, docket, okay, emphasizes. The court declines to do so. Now, this is what, okay, let me just finish. The court declines to do so, Applying the current version of 18 USC Section 3283 does not impair any of the defendant's rights because the statute was amended before the original limitations period expired. This court will not disturb well-settled law to create new statutory rights where none currently exists. Counts 1 through 4 are timely. Wow. Number 2, counts 6 through 8. Count 6 charges all defendants with conspiring to receive child pornography in violation of 18 USC section 2252A, A2, and B1. The indictment states that the conspiracy took place between 2001 and 2007. Count 7 charges defendants Kelly and McDavid with receiving 2 videos of child pornography in violation of 18 USC section 2252A, A2, and A2. The indictment alleges that Kelly and McDavid received these videos in August of 2001. Count 8 charges defendants Kelly and McDavid with receiving 1 video of child pornography in violation of that statute. The indictment states that Kelly and McDavid received this video in April of 2007. Defendants argue that counts 6 through 8 are subject to the general 5-year statute of limitations and are now untimely, stating that unless otherwise provided by law, the statute of limitations for a non-capital offense is 5 years. The government argues that the court should apply the statute of limitations set forth in 18 USC section 3299. According to that statute, there is no statute of limitations for an offense under Chapter 110 of Title 18 of the United States Code. Counts 6 through 8 all charge defendants with violation of Section 2252, which fall under Chapter 110 of Title 18. As such, Section 3299 applies to count 6 through 8. Section 3299 became effective on July 27, 06. The court finds that counts 6 through 8 are timely. First, count 6 and 8 of the indictment both state that the conduct in question concluded after 18 USC section 3299 was enacted. Therefore, that statute clearly applies, and a prosecution for these counts can be brought at any time, including in the current indictment. The accused conduct in count 7 took place before 18 USC 3299 was enacted. The court applies the Landgraf test to this count. In the first step, the court finds that the text of 18 USC section 3299 is silent as to its proper reach. In the second step, the court finds that applying the statute would not impair the defendant's rights. In drawing this conclusion, the court once again applies Gibson, was enacted on July 27, 06. The parties dispute what statute of limitation applied to count 7 during the time of the accused conduct. The defendants argue that count 7 is subject to the general 5-year statute of limitations, 18 USC section 3282 sub A. The government argues that the limitations period extended until the relevant minors turned 25, as specified in that it wasn't as specified in in 18 USC section 3283. The court notes that the dispute is largely irrelevant here. Either way, count 7 is timely. Applying the shorter limitations period of 5 years, the statute of limitations would have expired in August of 06. As 18 USC Section 3299 was enacted before the original limitation period expired. There is no ex post facto problem, meaning defendants' rights are not infringed. And they cite the Gibson case. Once again, the court applies 18 USC Section 3299 here. Count 7 is timely. Number 3, counts 9 through 13. Counts 9 through 13 of the indictment charge defendant Kelly with knowingly enticing minors to engage in sexual activity in violation of 18 USC Section 2422, sub B. In addition, counts 9, 10, 12, and 13 charge defendant Kelly was aggravated. Oh, I'm sorry. Uh, Let me repeat that. I'm sorry. In addition, counts 9, 10, 12, and 13 charge defendant Kelly with aggravated criminal sexual abuse in violation of 720 ILCS 5/2-16D. The indictment states that the activity occurred between 96 and '01. Like the charges 1 through 4, 18 USC Section 3283 provides that relevant statute of limitations. At the time of the accused conduct, the limitation period expired when the minor turned 25 years old. The earliest date at which any minor in the accused conduct turned 25 was August of 2005. As discussed earlier, 18 USC Section 3283 was amended in 2003, extending the limitations period to the life of the child. Earlier in this order, the court analyzed the applicability of the amended version of 18 USC Section 3283 to counts 1 through 4 of the indictment. The analysis for counts 9 through 13 is largely the same. Applying the first step of the Landgraf test, the court finds that the 18 USC Statute 3283 does not explicitly prescribe its proper reach. In the second step of Landgraf, the court applies Gibson. Defendant Kelly's rights are not infringed because 18 USC Section 3283 was twice amended before the previous limitations periods for counts 9 through 13 expired. The court applies the current version of 18 USC Section 3283 to counts 9 through 13. Counts 9 through 13 are timely as well. In sum, defendant's motion to dismiss is denied in its entirety. B. Motion to sever. Defendant Kelly has also filed a motion to sever. Kelly requests that defendant McDavid be tried separately and that counts 10 through 13 be severed from the rest of the indictment. Federal Rule of Criminal Procedure 14 authorizes district courts to, quote, order separate trials of counts, sever the defendant's trials, or provide any other relief that justice requires, end quote. That's Federal Rule Criminal page 14. District courts have discretion to grant the relief they deem proper, whether that is severance or something less drastic, such as a limiting instruction, and they cite a case here. In cases involving conflicting defenses, severance is not required, even as prejudice to a defendant is shown. A court must only grant severance, quote, if there is a serious risk that a joint trial would compromise a specific trial right of one of the defendants or prevent the jury from making a reliable about judgment. They forever having typos, and let me read that part over. If there is a serious risk that a joint trial would compromise a specific trial right of one of the defendants or prevent the jury from making a reliable judgment about guilt or innocence. Number one, severing defendant McDavid. Defendant Kelly argues that McDavid should be tried separately because of antagonistic defenses and because one of McDavid's lawyers may have a potential conflict of interest. In the motion to sever, Kelly alleges that both he and McDavid may present evidence against the other. Kelly alleges that he intends to present evidence that McDavid controlled the purse of the operation and pushed Kelly to continue to work to keep the money flowing. Kelly also alleges that McDavid might be used as a witness against him. Kelly's allegations do not provide further detail. Kelly argues that severance is required because he intends to show that McDavid had an interest in Kelly continuing to work. However, as the government points out, this evidence is not necessarily antagonistic to or even inconsistent with McDavid's possible defense. It is entirely possible that McDavid pushed Kelly to continue working and also conspired with Kelly to conceal his misconduct. As presented, Kelly's motion reads as blame shifting. Blame shifting among co-defendants does not mandate severance, states a case here. Moreover, Kelly does not specify exactly what evidence he expects to present that will compromise any of McDavid's trial rights, nor does he specify what evidence he expects McDavid to present that will be used against him. The motion does not raise any serious risks of impeding defendants' trial rights or that a jury would be prevented from making a reliable judgment. Kelly next argues that McDavid's lawyer, Vidam Glosman, may have a conflict of interest. Kelly retained a lawyer named Ed Jensen to represent him in a criminal case, resulting in Kelly's acquittal in 2008. Between 2008 and 2018, Kelly frequently consulted with Jensen. Glosman was an associate at Jensen's firm from 2014 to 2018. Kelly argues that through this connection, Glosman may have privileged information that could be used to Kelly's detriment. Glosman denies that he has any privileged information about Kelly. Glosman stated that his only conversation with Kelly and the first time he met Kelly was at Kelly's indictment hearing for this case. Kelly does not identify any privileged information or any class of privileged information that he alleges Glosman assessed. Kelly submitted a declaration on his own behalf where he states that he does not have a specific memory of ever consulting with Vidam Glosman. All Kelly offers is that he has a distinct memory of Glosman's name as someone who worked with Mr. Jensen. Kelly has not presented sufficient information to show that Glosman has an actual conflict of interest. The court will not sever McDavid and Kelly's trials. Counts 2, 10 through 13. Kelly argues that counts 10 through 13 should be severed from the rest of the indictment because he will suffer substantial prejudice otherwise. Severance may be warranted if defendant is improperly coerced into testifying about a count on which he wishes to remain silent. They state a case here. When a defendant seeks to sever charges because he wants to testify to some charges but not others, he must show that he has a strong need to testify on one count but not the other. They cite a case here. Kelly alleges that the evidence in support of counts 1 through 3 is stronger than the evidence in support of counts 10 through 13. In support of his argument, Kelly states that counts 1 through 3 are supported by video evidence, while counts 10 through 13 are supported by testimonial evidence. Kelly argues that he has important testimony to give concerning counts 10 through 13 and a need to refrain from testifying as to counts 1 through 3. Kelly's motion to sever does not specify exactly how he will be prejudiced if all the counts are tried together. Kelly does not adequately explain his assertion that the evidence in support of counts 1 through 3 is stronger than the evidence in support of counts 10 through 13. Kelly claims that the video evidence is much stronger than testimonial evidence of questionable veracity, but fails to provide more detail. Further, Kelly's motion fails to present evidence showing why he has a need to testify on only some of the counts. Kelly's motion asserts that severance is warranted, but does not provide specific evidence in support of that assertion. For that reason, the court denies Kelly's motion to sever. Conclusion. For the reasons stated herein, defendant's motion to dismiss and Kelly's motion to sever are denied. Nothing surprises me anymore, so I'm not surprised at all. And I also learned today, we were talking about if he was sentenced, what he would have to pay. And the government is charging him, trying to get back to that page. The criminal monetary penalties are assessment of $900. He was fined $100,000, and the Justice for Victims of Trafficking Act assessment is $40,000. So what they're going to take from him, and determination of restitution is deferred until September 28th. An amendment judgment in the criminal case will be entered after such determination. But what he has to pay immediately is the $900. That is to be taken immediately. So if he had that in his commissary on his books, they took it. This is what that attorney told us what would happen. So that's the update on the New York case and the Illinois case. And I just want to say this for the people that's out there that think this is a joke and that this is about children. The charges listed here is for racketeering and Mann Act transportation. Okay? If you follow this trial, we already know why they charged this man with the Slave Act. I think I said I was so frustrated the day of the sentencing. I think I said 1910, but I think the Mann Act was actually not in. I want to say 1918. Yeah, they couldn't get him anywhere else, so they had to. Oh, so I was right. It is not. I just Googled that. I was right. It is 1910. Wow. Yeah, so he's been convicted 30 years of prison on a slavery act from 1910 and also for racketeering, just so you guys know. And that's it. I have nothing else for you guys. I just wanted to update you on that. If I get something else, I will update you guys again soon. As you can probably tell by my tone, I'm still sort of in a state of shock, but it's not for the fact that he was sentenced, because we knew that was going to happen. I'm still in the state of shock of the length of time that this judge gave him, with all the proof that we know this man is innocent. And these people out here are just having a field day because they haven't educated themselves. That's why I'm not entertaining any of it, any of their comments, any of the nonsense that I've been hearing, even on these other channels, whatever. Now, if you've done your real homework, we could communicate, but you just want to be an idiot, I'm going to let you be that and let you believe what you believe. Okay. Unfortunately, guys, I was just looking at the additional counts of the conviction. Jane Doe number 5 is all through here. Jane Doe number 5, you should be ashamed. Have a good night, guys. Again, let me apologize. I am so sorry. I didn't want to do a live. I'm just not ready to come live right now. I'm still so disappointed in how this matter was handled, So, still praying for my guy, and I will continue to pray for him. Um, and I just feel sorry for these people that just refuse to accept the fact that this man is really this case. The man is innocent, people, and I'm going to keep saying that. And say what you want about me, I wouldn't be saying it if I didn't have the proof in front of me that those women, those actors, uh, if I didn't have it, I wouldn't even be saying it. So why don't you guys really do some research and stop running on the bandwagon with these people that's saying that he deserved it. He's been doing this for 30 years. You people sound very, I'm going to keep it real, you sound ignorant. You sound ignorant to somebody like me because I've been keeping up with the case. You're just following the news media, which they haven't reported anything on this man until something else came up that fits their narrative, and that's the 30-year sentence. So, have a good night, everyone, and I will talk to you guys soon. Soon. I love my virtual family. I love you guys. You guys are truly the best. So I hope you understand where I'm coming from. I just can't do live right now, man. I'm good. It's just that, I hate ugly things, and this is just an ugly situation, and it's going to be a minute. Okay. Take care. Talk to you guys soon. Enjoy the rest of this long weekend. Yeah, this is the holiday weekend, so I have to snap out of it, but just not right now. I mean, I'm good. This shock of this 30-year thing has to, I got to get past the 30 years. That judge went way beyond. I'm telling you guys, the experts in that report, the expert told them that the government was really reaching, that he shouldn't get anything if they were going to sentence him 10 years or less, and they were recommending less. And she comes back with a 30-year sentence. I found that very odd. That's why I'm not shocked by Land Weber's denying those motions, because I see it. I get it now. I get it. I get it. And for those of you want to know, because about all these videos you guys talking about, let me tell you what R. Kelly revealed. So you guys want to put this man in this box that he's just the freak of the freak. No. R. Kelly was videotaping those acts with his girlfriends as his proof in case someone said that he took advantage of them. what he had was showed that it was consensual and not forced. So I just want you guys to know that. See, you guys don't know what you're talking about. R. Kelly kept it real, very real with those medical experts. Very real. The man he's not a pedophile. Let me put that out there as well. These are Harvard experts that met with him and examined him before he was sentenced. They saw the real man. That's why they recommended what they recommended. So get your facts straight before you get on here and on the news looking ignorant. And you women, I can't believe you women. Wow, I'm just curious. What do those people have on you guys to convince you to go all the way? I didn't see who was crying, but I don't think you were crying because of what possibly happened to you. You were crying because you couldn't believe what they're forcing you to do. That's how I want to look at that. And when you heard the 30 years, you could have fallen to your knees. That's how I want to look at this. That guilt ate your asses up. That's how I want to see this. Because you know nothing truly happened to you. You guys walking around with this Alvarez like she's the God sent. I mean, like she the best thing could have happened to you people. And you just don't understand. You just easy money for this woman. Do you think that woman really care about you guys? You are a bank for her. And that's sad that you don't see that. Why did you take this since she's making so much money? Why didn't you take it to a sister? You got black lawyers that would have taken your case. Why did you go to this woman? You people are programmed, you don't even know it. But I'm not even going to get heavy on that because it is what it is. And it's not over until it's over. I'm still saying R. Kelly will be back. Take care, guys. Have a good night. Talk to you soon. Bye bye.